Awesome. Supreme Court cases. So we're going to speak about landmark Supreme Court cases. We're going to go through a list of court cases. They're currently in alphabetical, not chronological order. So like you can rearrange them if you want to. It's just how I created this slide. So we're going to talk about their relevance, what they mean for current U.S. law, and then at the very end, talk generally about why Supreme Court cases matter at all to anybody ever. Okay. So the first and most famous court case that everybody should know, especially for your like APUSH or AP US history, is Marbury versus Madison from 1803, one of the first Supreme Court cases. Marbury asked the Supreme Court to force President Jefferson to take actions in the matter. The Supreme Court said the law that would allow it to force the president to do something was unconstitutional. So now the Supreme Court has the authority to review/rule on actions of the other two government branches, and it established the Supreme Court's power of judicial review. So it's basically how the Supreme Court got its first precedent and power to review actions taken by the executive branch and by the legislative branch. It's how the court basically got its job. Miranda versus Arizona is a separate court case from 1966, and because of this court case, police must inform suspects of their legal rights. It strengthened the Fifth Amendment right against self-incrimination, and its long-term effect is that anyone being arrested must be read the Miranda warning, which says you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney present during questioning. If you cannot afford an attorney, one will be appointed to you. Do you understand these rights? So Miranda was retried and convicted based on other evidence besides his confession. He served 6 years, moved back to his old neighborhood, and sold autograph signatures for police officers' Miranda cards. He died later in a bar fight in 1976, but his arrest and a lack of rights being read to him during his arrest and information he said being used against him led to the Supreme Court case of Miranda versus Arizona, which went all the way from appellate courts to federal courts to Supreme Courts, and strengthened individual rights and protections. Tinker versus Des Moines is a Supreme Court case from 1969. It strengthened the First Amendment rights of students. This was an example of high school. This is a pretty famous case. High school students were wearing armbands, black armbands around their wrist to protest the Vietnam War, a very hot button issue with the youth of the day. And schools, the school did not like it. Like Des Moines was just like not about the fact that students were doing this. This is very similar to modern instances of perhaps people showing up to school and wearing a different kind of protest gear, maybe a large shirt that says Black Lives Matter, and your principal not totally liking that. The court ruled that schools can only limit student expression for valid reasons that could reasonably and demonstrably interfere with the purpose or goal of education. And this was like not one of those things. Tinker got to keep their black wristbands against the Vietnam War, and we love that. Texas versus Johnson is a Supreme Court case from 1989, and it ruled that flag burning falls under the protection for the First Amendment right to free speech. It was a pretty seminal case because the court had not previously ruled on flag burning, and it became a big re-election issue for individuals who were siding on what side of the issue they were falling on. And it solidified, I think, free speech in the US in the context of symbolism. Now individuals had rights to use various symbols of any kind, including the flag, under a right to free speech. Texas versus Johnson also established strong precedent for various kinds of speech tests. Some of them we refer to as the raindrop test. Some of them we refer to as like the imminent danger test, and we'll talk more about those in a moment. Ingle versus Vitale was a Supreme Court case from 1962, and it banned prayer in the nation's public schools. And it strengthened the First Amendment by arguing that the First Amendment prohibits the government from respecting an establishment of religion. And it was a big, I think, one of those big court cases that a lot of individuals in the nation are actively following, and whose ruling at the time meant a ton for individuals. But I think nowadays this is like one of the more common ones. We know that that teachers aren't allowed to force or lead prayer in public schools, especially because at the time of the court cases litigation, prayer very explicitly meant Christian prayer, as opposed to any other religion's kind of prayer. The Regents of the University of California versus Bake is a Supreme Court case from 1978, where the Supreme Court upheld the constitutionality of affirmative action based on the 14th Amendment's Equal Protection Clause. It says that race can now be used as criteria for college admissions, but may not use things like racial quotas, but they may proactively do things like solicit students' race to try and ensure that the college has like a fair number of students, that kind of thing. But they're not allowed to establish explicit quotas for admissions officers. Regent of the University of California versus Bake. Furman versus Georgia in 1972 strengthened the 8th Amendment, which states that individuals have a right against the use of cruel and unusual punishment. States were applying the death penalty inconsistently based off of race, according to Furman versus Georgia, 1972. The long-term effects of the case were that it required states to write guidelines for when the death penalty should be applied, and it also said that the death penalty cannot be used as an automatic punishment for rape cases. It was a strengthening of the 8th Amendment and a better establishing of what we would call human dignity-based laws in the US, a lot of which don't exist. The majority of the rights that you enjoy are based off of nationalism, not frameworks of human dignity, but there's some of them that are vice versa, and this is one of those. Gregg v. Georgia, 1974, the Supreme Court ruled that the death penalty was being applied constitutionally. Georgia had rewritten its death penalty laws to be applied consistently. So here's some context. The night before his set date for execution, together with 3 other condemned murderers, Gregg escaped from the Georgia State Prison. The night before his set date for execution. Together with 3 other prisoners condemned murderers, Gregg escaped from. This is the same sentence over and over, and it's not supposed to be the same sentence over and over. In Reedsville, in the first death row breakout in Georgia history, dressed in homemade prison guard uniforms complete with fake badges, the 4 had, and now my slides are in the way, so I can't complete. There we go. The 4 had sawed through their cell bars and then left in the car parked in the visitor's parking lot by an aunt of one of them. Gregg was beaten to death by individuals in North Carolina. And the night before his execution date. Sorry, my laptop's being really finicky. And so part of the charge was the death penalty applied constitutionally here? The man was not killed in the way that the state had planned he was going to be killed. He was killed in a more vigilante fashion by guards. And the Supreme Court ruled that because the state had still carried it out, it was still constitutional. So it was a really big deal historically. Gideon versus Wainwright in 1963 pertains to the 6th Amendment, and it says that all accused persons are entitled to a lawyer, and states must provide lawyers if conviction may result in prison time. So now you have a legal right to defense. And it helps to bolster the 6th Amendment. And many also consider it to be an expansion of the strengths provided by the 14th Amendment, or equal protection under the law. Mapp versus Ohio in 1961 says that evidence that is obtained illegally cannot be used in court. So if the police break into your house without a warrant to steal a small bag of illegal paraphernalia and then use that to convict you in court, it is not legally obtained evidence. so it cannot be used to incriminate you in court because of Mapp versus Ohio. This strengthened the Fourth Amendment, which allows you protections against unreasonable search and seizure. So if the police or the district attorney's office find things on you, unless those things were obtained legally, with due process, with things like warrants or reasonable suspicion, then those things cannot be used to incriminate you. This leads to the right that you have not to incriminate yourself at the same time. While it strengthens the Fourth Amendment, I think it inadvertently also strengthens the Fifth Amendment by not forcing you to comply with scenarios that put yourself in danger in terms of incrimination. Hazelwood versus Kuhlmeier is a case from 1988, and it was a pretty big deal. It said that school officials can censor school newspapers, and it weakened the First Amendment rights of students. It says that school officials could censor things that interrupted with educational activities or that harmed the reasonably accommodating environment of a school. School officials censored teen pregnancy articles in the school newspaper in this specific case, and they went to the Supreme Court for it, and the Supreme Court ruled that students gave up implicitly some constitutional protections when they crossed the threshold and entered public school property. This was a kind of a big reversal of the 1962 case that allowed individuals to wear black wristbands on their arm and establish protections for students. This is a sign that says "Bong hits for Jesus." It's like relevant to a Supreme Court case. I'm not just showing y'all this for fun. So Morse v. Frederick is a U.S. Supreme Court case where the court held 5-4 that the First Amendment does not prevent educators from suppressing student speech that is reasonably viewed as promoting illegal drug use at or across the street from a school-supervised event. So this poster, "Bong hits for Jesus," was being displayed across a school event. I think the school event related to a conversation around whether or not the school should allow, I think, like certain religious groups to use school property to meet. And Morse v. Frederick said again that the school has a right to interfere in the free speech of students. I didn't put a date here, but somebody can fact check me on this. I want to say that Morse v. Frederick was decided in 2007, but maybe it was 2001. It was definitely 2000. And just further weakening constitutional protections as they pertain to speech for students in schools. The Bethel School District versus Frazier in 1986. Frazier was punished for giving a sexually explicit speech at school, and it further said that school officials can censor student speech, and was the third major instance of weakening students' First Amendment rights in schools. This is a North Carolina Supreme Court case, but I think it's really pertinent. Even though it's not a Supreme Court case. The North Carolina Supreme Court decided that slaves are property of their owners and said that slaves could not be convicted for assaulting, slave owners could not be convicted for assaulting slaves. And the court based the decision on the state constitution, not whether it was moral. The state of North Carolina versus Mann ended up becoming seminal and later Supreme Court cases that had to do with persons and persons' rights. And persons' rights as they pertain to property. A Supreme Court case from 1829. It's also really important because the Supreme Court case kind of establishes the language of the law or the law of the land as it pertained to Black individuals during antebellum South, during slavery, and definitively kind of codifies into law for the South that Black individuals are property in 1829. Plessy versus Ferguson is a Supreme Court case from 1896, and it established the principle of separate but equal. It made segregation legal nationwide and codified racial segregation in Jim Crow South. Individuals had to do things like use separate bathrooms, use separate waiting rooms for hospitals, oftentimes use separate wings of hospitals, use separate schools, use separate water fountains, separate bathrooms, and segregation as far as housing goes, and really codified into law segregation nationwide, and is responsible for many of the disparities that we can note that are tied to segregation. This is a segregated school in Arkansas in 1949. You can see the black school on the left and the white school on the right. Just the change in access to resources plus how crowded they are. This is a high school for white kids in Prince Edward County, Virginia in 1963 under penalty of law, no trespassing. High school kids for African-American kids in Prince Edward County in 1963. Big difference between the series of Trigler houses, basically just thrown up here on the side of the road, and this large brick school which explicitly states that you can't trespass on that property. Message from the school board. And 117 African-American high school students chose to strike rather than attend all-black Morton High, which was in need of physical repair. The students initially wanted a new building with indoor plumbing to replace the old school, which lacked indoor plumbing. Strike leader Barbara Jones enlisted the assistance of the NAACP attorneys. A suit was filed in 1951 on behalf of the students, and the U.S. District Court ordered equal facilities be provided for the black students, but denied the plaintiffs admission to the white schools during the equalization program. Attorneys for the NAACP filed an appeal with the U.S. Supreme Court. And here we have Brown versus the Board of Education of Topeka, Kansas, which overturned Plessy versus Ferguson, and the Supreme Court finally in 1954 ordered the desegregation of public schools. The Leandro case is another North Carolina Supreme Court case that I think is really prominent for the law of the land. It said that all North Carolina children have a right to equal opportunity to receive a sound basic education. This is important, I think, for everyone to know. Very recently, a Chicago court, I think, ruled the exact opposite. So the Constitution does not guarantee any of you a right to education. Beyond that, it definitely doesn't guarantee any of you to any kind of quality of education that's measurable. It leaves education to the decisions of each individual state, which can decide in turn that you are worthy or not worthy of education because it's not a constitutional protection. This is real. You can all go do research on this. There's been an ongoing court case in Chicago as it relates to Chicago public schools. There are a number of Chicago public schools that are still quite literally more segregated than they were around Brown versus the Board of Education of Topeka, Kansas. And that has to do with not things like de jure segregation, but de facto segregation. Individuals having access to certain zip codes, access to housing loans, access to certain neighborhoods, etc. And in Chicago, there's a couple of schools that the literacy rates, the test scores, the education profiles show that some of these schools are far behind where those students should be, where we can not expect basic 8th graders to have 8th grade literacy rates. We can expect them to have 3rd or 4th grade literacy rates. The Chicago courts in Chicago ruled that was not a violation of students' constitutional rights because students have no right to quality education. This is a real recent ruling of a federal Chicago court. Students have no right to a quality education under the Constitution. This North Carolina Supreme Court case in 1997 ruled for the state that all NC children have a right to equal opportunity to receive a sound basic education, and the suit was filed by mostly poorer children, mostly African-American counties, and Judge Manning continues to fight for equal education for all students. I think he may have actually recently passed away. Perhaps he did not, but I think he may have. and trying to make education a national right, because it is 2020 and none of you have a constitutional right to education. There is a law that says people have to put you in school. There are truancy laws. Your parents will go to jail if you're not in school. But nothing about that school has to follow any guidelines for the quality of for your education. It is totally constitutional for you to graduate high school with a literacy rate equivalent to an 8th grader when you're 18, and we can still say you have not had your rights violated. So I think that we can expect to see in the next 10 to 15 years developments in this kind of avenue. I think that I'm hoping that a Supreme Court will rule sometime in my lifetime that the 14th Amendment guarantees us a right to quality education, because I think that that's more than reasonable, and it just hasn't happened yet. Swan versus Charlotte Mecklenburg is a U.S. Supreme Court case from 1971 that extended Brown versus the Board of Education decision. North Carolina was forced to dismantle its de jure or by law segregation in schools, and it upheld that the forced busing of minority students to ensure schools were integrated was constitutional. You can remember, if any of y'all watched some of the more early Democratic debates for the Democratic primary, busing was a big hot topic issue because U.S. Senator Kamala Harris was part of one of the first generation of students to be bused in LA from her neighborhood to a school to forced integration. So really, I think powerful to think about that Kamala Harris is part of a generation of people who had to integrate schools, and to show us that schools are quite literally today still segregated, and that these decisions are very recent, still moving through the language and law of the land, and still subject to revisions and new protections. Korematsu versus the U.S. is one of the nation's and also one of the world's more famous Supreme Court cases. It held that Japanese Americans held in internment camps during World War II were held there constitutionally. The court said that it needed to protect U.S. from spies, and that this outweighed the rights of Japanese Americans. It weighed that citizens' rights may be taken away in times of national crisis, without setting a clear, bright line in that court case for how citizens' rights could be taken away. Mr. Korematsu's conviction was overturned in 1983 for violating staying in the internment camp. Since then, reparations has been paid to many Japanese Americans who were infected by the imprisonment. But this Supreme Court case said that our internment camps, our imprisonment of Japanese Americans, of American citizens, was legal, was constitutional. So scary stuff, honestly scary stuff, because yeah. Heart of Atlanta Motel versus the U.S. is a Supreme Court case from 1964. The Heart of Atlanta Motel in Atlanta refused to accept Black Americans, and this was in violation of the Civil Rights Act, 1964. So the question that the Supreme Court had to review is, did Congress, in passing Title II of the 1964 Civil Rights Act, exceed its Commerce Clause powers by depriving motels, such as the Heart of Atlanta, of their right to choose their own customers? The decision, the Supreme Court said that Commerce Clause of Article 1 of the Constitution allows Congress to pass such laws that restrict the rights of certain companies. Places that serve the public have no right to select guests as they saw fit. So oftentimes you'll see signs that say things like, we maintain a right to deny service to anybody. By and large, that's not true. It's not ever been true. It's historically not really very true for the majority of businesses. It's kind of true for some private businesses, especially parochial or religious businesses. But by and large, a business that receives a federal loan, if they ever got money for their mortgage from the government, or if they reasonably service a public, then they don't have a right to select guests as they see fit. The cake baking debacle, it just strengthens this. We've always known this. We just kind of let people get away with it sometimes. McCulloch versus Maryland is a much older Supreme Court case from 1819. Again, the more I'm thinking about it, I should have done these chronological. I was just going alphabetical because like that's how my encyclopedia on Supreme Court cases was working. And McCulloch, my bad. McCulloch versus Maryland asked this question: did the state of Maryland have the right to tax a federal institution like the U.S. Bank located in its state? And it said that the states could not tax the federal government. This helps to establish the idea of federalism, and it upheld the idea of implied powers of the Congress. State actions may not impede Congress from anything that's necessary and proper to carrying out duties listed in the Constitution, like managing federal funds. Chief Justice John Marshall wrote the majority opinion in this case, and it's one of the older cases that we still use consistently to uphold implied powers or federal powers and federal privileges. Gibbons versus Ogden is a case from 1824. Gibbons had a license to run a ferry service from the U.S. government, and Ogden got an injunction from the state of New York to make Gibbons stop. So then the question was, does federal control over interstate, does the Fed control interstate commerce, and can a state law interfere with this power of Congress? And the verdict was that the injunction against Gibbons was unconstitutional. The impact was that the Commerce Clause of the U.S. Constitution gives Congress the power to regulate interstate commerce. So when it becomes a question of more than one state, then state laws are basically nullified. Again, this is part of the Implied Powers Clause, the Commerce Clause, and it just gives the federal more power and establishes federalism as a stronger principle of normal operations in the U.S., giving the executive power over interstate questions, especially as they relate to commerce. New Jersey versus TLO. TLO was accused of smoking in the girls' bathroom of her high school. A principal at the school questioned her and searched her purse, which yielded a bag of marijuana and other drug paraphernalia. The question was, did the principal's search of the students' belongings at the school violate the Fourth Amendment, whereby you have protection from unwarranted search and seizure, and the 14th Amendment, like a right to due process and equal protection under the law? The decision is that probable cause is not needed in school searches, and the principal must only have a reasonable suspicion, and that it doesn't infringe on their 14th Amendment rights. Again, this is just a further weakening of students' rights in public schools, which is I think just an absolutely fascinating phenomenon. If you ask me, this is really bad for civic education. Really, really bad for civic education. Think about what it might mean for students to be afforded full or large constitutional protections in their schools. Students would develop an affinity for, but also literacy of, their constitutional protections. People literally graduate school not knowing what protections they have. Why? Because they're constantly and consistently violated in school by principals. It furthers the schools as prison-like systems. I mean, like Foucault was right. He just didn't know it. And it, I think, damages civic education in terms of students' understanding of their relationship to government and their relationship to the Constitution. I think if TLO was able to get away with smoking in the bathroom, she might have learned her lesson from things like fear. Her parents may have gotten her in trouble, and she would have probably grown up with a much smarter, a much more appreciative understanding of her protections for the Fourth Amendment, and maybe she'd work for the ACLU now. I don't know. I just think that the decreasing of civil protections for students in schools is one of the most interesting phenomena in U.S. Supreme Court cases, and it's one that damages students' relationship to knowledge of the law and relationships with the law later in their life. I think it's bad for civic literacy and civic education, but it happens. Schenck versus the U.S. is a Supreme Court case from 1919. Schenck was arrested for protesting the military draft during World War II. The decision that the court held was that speech that presents clear and present danger to society is not protected by the First Amendment. what's really interesting is oftentimes we use like the fire analogy to illustrate this point. Like individuals can't yell fire in a crowded theater because it's a clear and present danger. But the initial Supreme Court cases language from 1919 had to do with anarchy. They were like quite literally policing thought on anarchy as presenting a clear and present danger to society. Now a lot of courts would have different interpretations of what is or is not dangerous. So it's, I think, one of the more messy Supreme Court cases as it relates to speech. And speech tends to be, by and large, more protected than not protected by courts. So I think it's okay that it's a bit more messy. But it was initially just against the kind of ideological ideas of anarchism being not only pronounced, but also practiced. Escobedo versus Illinois is a Supreme Court case from 1964 featuring Danny Escobedo. Escobedo was arrested for murder. They asked for an attorney, but they were denied. They confessed to the crime and they were convicted. And the decision is that the conviction was overturned because suspects have rights to an attorney when arrested. It's one of the first cases of the Supreme Court overturning an individual conviction. And it strengthens and upholds the 14th Amendment and strengthens the previous Supreme Court case, whose name I forget, that guarantees you a right to an attorney. This is Chief Justice Earl Warren. During his time as a court justice of the Supreme Court, or Chief Justice of the Supreme Court, he was called as the head of the activist court because of his expansions of rights of the accused, as opposed to the rights of victims, but whatever. They served from 1953 to 1969, and these are some famous court cases that they've overseen: Mapp v. Ohio, Escobedo versus Illinois, Miranda versus Arizona, and Gideon versus Wainwright. And these are all cases during the Warren tenure as Chief Justice. Many of these cases are good for people insofar as they expand your access to 14th Amendment rights, and they protect you by and large from the state, though they also, I think, protect the accused in ways that Chief Justice Earl Warren may not have predicted in our modern day society's villainization of some victims. Gitlow versus New York is a Supreme Court case from 1925. Gitlow was a socialist. As a socialist, he was arrested with violating New York's law against advocating for the overthrow of the government because he published a socialist pamphlet. The Supreme Court overturned his conviction. They said that states cannot violate the First Amendment right of free speech because of the 14th Amendment due process clause, which is really interesting because the case, as it relates to anarchy, kind of says like the exact opposite thing on speech. So shows some of the ambiguity in ways that individuals can use precedent to protect themselves on speech, but also ways in which the government can just kind of like rule in their favor when it applies not just to states, but as a threat to the executive or to the federal government. DeJong versus Oregon is a case from 1937. DeJong was arrested for organizing the Communist Party and speaking against U.S. government at their meetings. The Supreme Court said that the 14th Amendment and due process clause protected him, and that was really good. Brandenburg versus Ohio is a famous Supreme Court case from 1969. Brandenburg was in the KKK, and he made a speech promising vengeance against Black individuals and Jews. He was arrested for violating Ohio law against advocating violence, and the court ruled that states cannot punish free speech unless it presents the imminent danger of violence, and that there has to be clear evidence that the violence is imminent. And apparently this was not. Roe v. Wade in 1973 is a very famous court case. It says that can states make laws that ban abortion? And the decision was that individuals have a right to abortion as protected by their rights to privacy, a constitutional right that they have to privacy that means that states cannot make laws banning abortion. Roe versus Wade. It's important to note that Jane Roe, the woman who was the plaintiff in Roe versus Wade, never actually got to receive an abortion herself. The litigation of the case took far too long. She ended up giving birth to the child. She never received the abortion that she fought for. And then there's a recent documentary that came out known as AKA Jane Roe, because you may have encountered in your lifetime somebody who wants to engage in a either good faith or bad faith debate with you about whether or not individuals have a right to abortion. And they may have mentioned that Jane Roe, the plaintiff from the case, is against abortion herself. This is just not true. It's it may have been true at one point, but you can watch the documentary about Jane Roe. Jane Roe and her lesbian partner were both paid several $1,000s a week if they agreed to both denounce their homosexuality and openly come out against abortion. And they were paid by conservative political action committees. So Jane V. Roe was never against abortions. She was paid lots of money as a person that had low financial security by a conservative political action committee to say that she was against abortion and to pretend that she was not a lesbian. And really interesting also because I think that Jane Roe's involvement in the Roe versus Wade case was also an example of coercion on the part of the lawyer. I don't think that Jane Roe ever wanted to go to the Supreme Court. Obviously, the case wasn't for her. She was not able to get her abortion. She was more actually just used by the team of lawyers that was trying to advance this case. So Jane Roe is a really interesting example of a woman who I think was used by people on both sides of the aisle and who large legal precedents in the US have been carved out around, but a woman who never actually experienced those legal protections herself. And this is the last slide that we have on this case. And there are, I think, some other interesting, very recent Supreme Court cases that individuals should look into. One of the ones that I think are very important to groups is Kelo versus New London. Kelo versus New London is a Supreme Court case where the Supreme Court ruled that the government can take away individual private property for the purposes of economic revitalization. They basically ruled that eminent domain could be used to revitalize blighted neighborhoods. And it allowed eminent domain to be used for the purposes of gentrification. This built off of a previous Supreme Court case known as the Housing Authority of Hawaii versus, actually, I don't know. Housing Authority of Hawaii versus, Midkiff is the name of the plaintiff. The Hawaii Housing Authority versus Midkiff was a Supreme Court case in 1984, in which the U.S. Supreme Court held that a state could use eminent domain to take land that was overwhelmingly concentrated in the hands of private landowners and redistribute it to the wider population of private residents. This was influential in Kelo versus the City of New London, the Supreme Court case in 2005, where the case was ruled by the Supreme Court that eminent domain to transfer land from one private owner to another private owner was totally legal and constitutional as long as it was being used for the purpose of economic development. If you ask me, I have no idea why that's legal, but it's totally fine. Some other, I think, really important Supreme Court cases. Lawrence v. Texas is a Supreme Court case that was established in 2003. Lawrence v. Texas, the government, the Supreme Court ruled on the side of Lawrence, not on the side of Texas. Lawrence v. Texas was a landmark decision of the U.S. Supreme Court in which the court ruled that the U.S. laws prohibiting private homosexual activity between consenting adults are unconstitutional because Texas had a lot of laws that criminalized sodomy, and they legalized raids whereby police officers could try and identify houses of gay men and just like raid them to try and like catch them in like to like try and just like send them to jail. Lawrence v. Texas basically legalized same-sex activity in the U.S. because same-sex activity up until 2003 was not legal all across the U.S. In fact, it was very illegal still in 2003 in many parts of the U.S. Another Supreme Court case that I think is important to consider. Sorry, another one just like coming to me. I just like forgot to add them to the slideshow because I made this slideshow the other day when Piper told me I was giving this lecture. It's Bowers versus Hardwick. Bowers versus Hardwick is a Supreme Court case from 1986. And it is what Texas v. Lawrence overturned, because in Bowers versus Hardwick, Bowers tried to say that U.S. laws that criminalized same-sex sexual activity were unconstitutional, but the Supreme Court ruled that the laws that banned or criminalized same-sex activity were totally constitutional. So Texas v. Lawrence just overturned Bowers v. Hardwick. And a really, I think, awesome moment for queer people in the U.S. And similar to another case on sexual autonomy, Griswold versus Connecticut. Griswold versus Connecticut is a case decided in 1965. It was a landmark decision of the Supreme Court in which the court ruled that the Constitution of the U.S. protects the liberties of married couples to buy and use contraceptives without government restrictions, because some cases were not allowing individuals to buy contraceptives or to buy birth control. And we ruled that this was a violation of individuals' privacy, the exact same way that we have upheld individuals' right to receive an abortion. Another case that I'm sure, I really hope you're all familiar with is Obergefell versus Hodges. Is a landmark Supreme Court case decided in 2015, so not too long ago, in which the U.S. Supreme Court ruled that the fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the U.S.'s 14th Amendment of the Constitution. Very, very important recent Supreme Court case that I think matters a lot.
That one called?
What was that?
What was that last one called?
Yeah, I'll throw it in the chat. It's Obergefell versus Hodges. It's like kind of hard to pronounce because like they're people's names. But I'm gonna throw it in the chat. This is 2015. It is also known as the marriage equality ruling. And in 1967, another Supreme Court case that pertains to autonomy of individuals and to love was Loving versus Virginia. In Loving versus Virginia, this is another landmark Supreme Court case. The U.S. Supreme Court ruled that laws that banned interracial marriage were unconstitutional insofar as they violate the Equal Protection Clause and the Due Process Clause. So I hope that we're seeing a trend here, that like the U.S. government is really prominent at creating laws that say that we can't do certain things, and most of those laws tend to violate the 14th Amendment. So the 14th Amendment is like awesome. It's OG. It's how we've gotten most of our rights and the majority of modern progressive rights for individuals have come from the 14th Amendment. Awesome. I think there's two more that I want to look up. One is New York Times versus Sullivan. New York Times versus Sullivan was a Supreme Court case from 1964. It was a landmark decision of the U.S. Supreme Court that ruled that freedom of speech protections in the First Amendment to the U.S. Constitutions restrict the ability of the American public officials to sue for defamation. In other words, elected officials like Donald Trump can't sue the New York Times for posting or writing bad things about them that call them maybe a bad president. Really important for the U.S., especially in terms of our political history. And the second one that I want to expose you all to is the New York Times versus the United States. This is 1971. In the New York Times versus the United States, the Supreme Court ruled on the First Amendment. The ruling made it possible for the New York Times and the Washington Post to publish the then classified Pentagon Papers without risk of government censorship or of punishment. And it basically gave the strongest protections we've ever seen to the free press in any country, because the New York Times published classified material and got away with it. Really, really, really big deal. Racking my brain trying to think if there's like any other Bush v. Gore. Everybody needs to be familiar with Bush v. Gore. Bush v. Gore was a Supreme Court case from 2000. And in Bush v. Gore, the U.S. Supreme Court settled a recount dispute in Florida's 2000 presidential election. On December 9th, the court had preliminarily halted the Florida recount that was occurring, and they ruled essentially that the recount was in favor of Bush. They essentially handed Bush the argument, the election. It's a huge deal because it's the only time in history that the Supreme Court intervened in a federal election for the president, an executive election. So what happened was Bush versus the Palm Beach County Canvassing Board, and argued that they wanted a recount of votes. So on December 8th, 2000, the Florida Supreme Court ordered the Circuit Court in Leon County to tabulate by hand 9,000 contested ballots from Miami-Dade County. It also ordered that every county in Florida must immediately begin to manually recount all undervotes or ballots which did not indicate a vote for the president, because there were enough contested ballots to place the outcome of the election in doubt. Governor George Bush and his running mate, Richard Cheney, filed a request for review in the U.S. Supreme Court and sought an emergency petition for a stay of the Florida Supreme Court's decision. The U.S. Supreme Court granted review and issued the stay on December 9th, and it heard oral arguments 2 days later. The question was, did the Florida Supreme Court violate Article 2, Section 1, Clause 2 of the U.S. Constitution, Article 2, Section 1, Clause 2 of the U.S. Constitution, by making new election law? Do standardless manual recounts violate equal protection and due process clauses of the Constitution? So this is crazy. This is like literally crazy. The Supreme Court was like, Florida, stop recounting. Bush, you win the election, because the Florida court was legislating. This is to this day, because it was only decided 20 years ago. To this day, a very highly studied and highly contested and controversial Supreme Court case. It's also, I think, highly convoluted insofar as the legal scholarship is not easy to access. But it's a big, big deal, because the Florida Miami-Dade County's approach to solvency was just like manually recount ballots. But Bush didn't want that to happen because it might mean he might lose. So the Supreme Court was just like, Bush, you can become president. And then Bush was president. And then we went to war in Iraq. So crazy. Like, if you talk to any Democrat who is like over the age of 20 to 25, I promise you this is like one of the things that makes them most angry to this day. It is arguably, in terms of political impact of your lives, the most consequential Supreme Court decision that we've ever seen, insofar as it just like handed the president the election and rechanged conservatism for, I think, like the next 20 to 50 years. But there's also a lot of other recent Supreme Court cases that really impact your lives, like DACA, which the Supreme Court is ruling on and actively ruling on all the time right now, and different Supreme Court cases that are heard every single spring. So keep up with Supreme Court cases because they're fascinating. They're really, really big deals. And I think that they're important, and people don't often understand what they mean for you or what they mean for the nation. But they're awesome. I'm looking for something. Has anyone ever heard of the running of the interns? No? Okay. Y'all about to learn. All right, I'm gonna share my screen. Share screen. Does everyone see this? My screen? I just like Googled the running of the interns, and you can just see like people running across the Supreme Court. So like this is a thing that happens all the time. If the Supreme Court rules on a big decisions, all these people right here, like these like little college interns, will like take the Supreme Court decision and they'll like run, and they'll run all the way from the Supreme Court to the press office across the street where they can like have access to the internet, and they're like, here's the decision, and it's like really cool. So if you're a nerd like me for major Supreme Court cases like gay marriage, you will like wait to watch them run across so that you can like know what the Supreme Court has ruled. The running of the interns happened every time there's a major Supreme Court case. I don't know what I'm gonna do with my future, but it's totally possible that one day I would try and be one of those runners. It'd just be really cool to like to be like the first person to know what the decision is, and to have to like run and be like, the world, this is it. Because like we don't allow cameras in the Supreme Court still. Yeah, any questions? No questions? Awesome. Those are some landmark Supreme Court cases. The Supreme Court does whatever it wants. That's the truth. If you'll notice, a third of the cases may not be true. A number of the cases we went over was just the court being like, yeah, so the court before us was like wrong, you know? And courts are terrifying. Courts are terrifying. You should all be terrified of courts. Courts should, more than the presidency, more than Congress, courts should terrify you, especially U.S. courts. They just have absolute power. What's up, Ashton?
So how many cases does the Supreme Court hear every year?
It's up to them. Entirely up to them. They can hear as many or as little as they want to. They can decide whether or not to hear those in the forms of oral arguments or not oral arguments. And they normally hear, I want to say, like in a season, is what they call it. Like I'm going to guess 8 oral arguments, but I'm going to look it up so I'm not lying to you. I'm going to stop share. Okay. How many cases does the Supreme Court hear? Let's see, does the Supreme Court hear in a year? That's what I want. The Supreme Court is roughly asked to review around 7,000 cases. It will agree to entertain roughly 100 of those. It will take oral arguments from anywhere from 10 to 20 of those 100. A lot of them, go ahead.
Oh, I was just gonna say, so they turn away, like they just tell like 6,900 people no?
No, yeah. What they do is they say, give it to a different, smaller court. And most of what happens is the Supreme Court will agree to hear things as they climb up different courts. So you'll go to like a court in Texas, that's a federal court, and it'll rule something. And then you can appeal, and you'll go to a higher district court. And then you can appeal, and then you can go to the Supreme Court. That's how most landmark decisions happen. They climb their way up a process of district, federal, Supreme Courts. But sometimes, like in Bush v. Gore, the Supreme Court will just say, hey, Like, we really want to hear that, and we're going to rule on it today. It's like, it's like up to them. They can decide what they want to hear and what they don't want to hear. And in doing so, they decide like what's a big issue and what's not a big issue. They tend to tackle issues that have the most pressing questions for constituents, right? So like, that's why they tend to tackle big topic issues like gay marriage or DACA and immigration. Sometimes they put things on pause because they have to hear things automatically. Like Trump will do things like put a Muslim ban, and the Supreme Court has to be like, I'm sorry, he did what? You know, and then they have to like go in and be like, no. The Supreme Court is controlled by what's known as the Chief Justice. The current Chief Justice is John Roberts. So we have what's called the Roberts Court, and he's famous for what's called the Roberts two-step. And in the Roberts two-step, Roberts will like do something that looks super progressive, like the recent Supreme Court ruling on like transgender rights, which isn't that progressive. The Supreme Court was like, transgender people are employees first and humans second. But he'll do something like rule super progressive ruling, and everybody will be like, yay! And then he'll do something like twice, really, really conservative rulings. And it's called like the Roberts two-step, because he'll be like, whoop, 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 whoop. And over the last few years, I think that Chief Justice John Roberts has been responsible for turning America into far more of a conservative place than it ever used to be. But it doesn't look like it because the Roberts two-step is super strategic. He'll do something like rule on gay marriage and then like be like, but you're not people, you know, and like it happens all the time. The Roberts two-step is a fascinating phenomenon that I think that we will study for years after John Roberts passes away. And if you interested in the Roberts two-step, there's lots of recent stuff on it, because I promise you he is scheming. He is currently scheming at the moment. Right now, the Trump administration is trying to, the Trump administration is, so like the citizenship question on the census was a really big, was a really big issue. And I think that the Trump administration is having a hard time with the Supreme Court, and Justice John Roberts is playing that two-step for Trump. And John Roberts is fascinating.
Who appointed him to the Supreme Court?
I am pretty sure that John Roberts is a Bush appointee, but I don't know. Let me find out. Chief Justice John Roberts was appointed by George W. Bush. Yes. Mm-hmm.
And do people ever resign from the Supreme Court, or do you have to pass away?
So you don't have to pass away. You can resign from the Supreme Court. There's people who have resigned from Supreme Court. I think that like it's not very many. I'm pretty sure that most people who have held it have died on the bench. Resignation or retirement is what the Constitution says. The justice's death, resignation, or retirement. When I Google how many people have resigned, it doesn't tell me, at least immediately. I think Anthony M. Kennedy, he was the last person to resign. He resigned, I think, for mental health issues. But I'm pretty sure a lot of Supreme Court justices serve until they die. Awesome. If there aren't any other questions, then I will see y'all.
Thank you.